Hello everyone, so welcome back to English Law, and this video is going to be about everybody's favourite topic, burglary. Let's vary piracy with a burglary, with a little burglary, as Gilbert and Sullivan wrote. So burglary is an offence at common law, but it's been defined by the Theft Act 1968 for the avoidance of doubt. You'll find it there in section 9.1a. There's also aggravated burglary as per the Theft Act, and that's in section 10 thereof. So this is what the Theft Act has to say in section 9. A person is guilty of burglary if he enters any building or part of any building as a trespasser with the intent to commit any such offence as is mentioned in the subsection below, or having entered any building or part of a building as a trespasser, he steals or attempts to steal anything in the building that or that part of it, or inflicts any, or attempts to inflict any person therein any grievous bodily harm. So let's go over the actus reus here. The defendant enters a building or part of a building as a trespasser. It could be that he's in the building but not as a trespasser. He's allowed in a certain room, but then he goes into another room where he's not allowed to be, and at that point he becomes a trespasser. So enters was defined by R against Collins. It has to be an effective and a substantial entry, as per R and Brown. Our effective entry was defined further in R against Ryan. So section 9.1a talks about the actus reus, a building. So what's a building? Well, in Stevens against Gourley, this case was held by a judge called Biles, and this is what the judge had to say about it. I may venture to suggest that by a building is usually understood a structure of considerable size and intended to be permanent, or at least to endure for a considerable time. Close quotation. For instance, a houseboat is a building, a tent is not. So in B&S against Leithley, a Norfolk Constabulary against Seekings and Gould, they define what exactly counts as a building. Caravans do, for example, part of a building. That came into R against Walkington, as in going from the zone where you are permitted to the zone where you're not, and at that stage you become a trespasser. If you're allowed in, and you're in some sort of room that you're permitted to be, and then you steal, that's theft but not burglary. Okay, so section 9.41 says references to a building shall also be held to apply to any inhabited vehicle or vessel, and shall apply to any such vehicle or vessel at times when a person having habitation in it is not there, as well as times as when he is. Close quotation. So it can apply to ships, because you could live on them. Even if you're not going to permanently live on them, you might well sleep in them, be there for weeks, months. Caravans, they're inhabited vehicles, mobile homes. So section 9.1a, the actus reus as a trespasser, and R against Collins dealt with that exceeding permission. That's in R against Jones and Smith, when they got permission to be somewhere, but they go beyond their permission to go to areas they're not allowed to be there, or stay at a time when they're not allowed to be there. So the mens rea here is knowledge or recklessness about being trespassers. You know that you're trespassing, or indeed you don't really care. It might not be, you're not sure, but it's not going to stop you. And that was held in R against Collins, as well as in R against Jones and Smith. So more about the mens rea. That's the mental element of the offence. There's the intention to commit the crime as defined in section 9.2. That's to steal any item in the building or anywhere in the building, as in you're allowed in one room, you go into a room where you're not allowed, okay, and that's part of the trespass. Or indeed you're there with a view to inflicting grievous bodily harm on anybody in the building. So notably, burglary is not necessarily about stealing items. It could be about GBH. So you could be where there's a trespasser when you're committing the GBH, okay, or committing unlawful damage to anything in the building or part of the building. So even if you're not taking anything away, if you're there to commit criminal damage, that's still burglary. Interestingly, although usually we know that burglary is about purloining items. So Attorney General's reference number 1 and 2 of 1979 held this: a conditional intention is still an intention. So section 9.1a, go back over it, the mens rea here is entering a building or part of the building as a trespasser. So that's the actus reus, and the mens rea is knowing or being reckless as to whether this is trespass, and intending to commit any of those offences which were cited in section 9.2, such as stealing an item, or causing criminal damage, or inflicting grievous bodily harm. So section 9.1b I'm talking about entering a building, and what do you have to enter? You have to enter a building or part thereof. You have to be a trespasser. You have to know you're trespassing or be reckless about whether you're trespassing. And you have to steal, attempt to steal, or inflict grievous bodily harm whilst there, or indeed criminal damage. So section 9.1b says that the mental state here is about grievous bodily harm, as per R against Jenkins. So you might see my previous videos about offences against the person. Grievous bodily harm is heavy violence. It's more than just slaps and kicks. It's not quite attempted murder. It stops short of that. And grievous bodily harm, you must break both the layers of skin, the dermis and the epidermis, even if the victim doesn't actually bleed. A grievous bodily harm can be committed with an implement, a bludgeon, a sharp thing, or indeed just with hands and feet. Okay, so why are there two crimes here? Entering it as a trespasser, but without the intention to commit burglary would not be a crime under section 9.1a, but you would be guilty under section 9.1b if you go on to steal something. However, if you come into the building as a trespasser without required ulterior intention, but you're unable to complete your objective, then you would not be guilty under section 9.1b, but you would be guilty under section 9.1a. So bear in mind R against Lang. It doesn't matter which offence you committed, the defendant must be a trespasser when he entered. Okay, if it was not a trespasser when he entered, he's not guilty of these things. Now, then there's aggravated burglary, as provided by for under the Theft Act, section 10. Aggravated means making it even worse. Okay, so the actus reus here is committing burglary, as per section 9.1a or b, and taking with you a gun or a replica of a gun or any offensive weapon. Could be a knife, could be a bat, any explosive, and sections 10.1a, 10.1b, and 10.1c go about these, even if you don't actually use them. Okay, so those are crimes. There's also the crime of going armed for burglary, as in, what are you doing outside a jewellery shop at 3 o'clock in the morning wearing a balaclava with a sack, a crowbar, a light, and so on, and skeletonic keys? Even if you didn't actually start to commit your burglary of the jewellery shop, this is, I suppose, an inchoate offence, going armed for burglary. Okay, so aggravated burglary continues, so you have to have a weapon of offence. So section 10.1b says, is any object which is made or adapted with a view to injuring people, incapacitating a person, or aimed to be used by a person to injure or incapacitate others. It has to be used against humans, or capable of being used against humans. It doesn't matter if you don't actually use it against humans, but it could be, and that's the purpose of you having it. Like a cricket bat, it's got a legitimate purpose, but if you're bringing it there with a view to using on someone or threatening somebody with it, then that would be an offensive weapon. So that's per section 10.1b. R against Stones and R against Kelly are cases about this. And you have to have it with you at that moment that you're there committing the burglary. That was found in R against O'Leary, R against Kelly, and indeed R against Hale. So that's just a little bit about burglary. I hope you found that illuminating. Please book online lessons with me, George from Ireland, in English as a foreign language, English literature, English language, history, politics, citizenship, religious studies, geography, French. At a lower level, I can do maths and science and so on. So see my other channel, George from Ireland. So I hope you are finding this useful, this law channel, and book online lessons with me. Toodaloo.